A few seconds for everybody to enter the webinar, then we'll get started. Welcome again, everyone. Thank you for joining us for our second webinar in our CLE series, Key Legal Considerations for Businesses Reopening and Rebounding. Today's program will focus on contract considerations regarding force majeure in the COVID-19 era. My name is Jared Hawk, and I'm a partner in the firm's Pittsburgh office. My practice focuses on product liability, commercial, and energy litigation on a national basis, and I'm also the leader of the firm's force majeure litigation team. I'm accompanied today by two of my colleagues. The first is Sweta Gandhi, who is counsel in our firm's corporate practice. Sweta is a resident in our Baltimore office and concentrates her practice in general business and commercial law and assists businesses with significant transactions that help them adapt to the marketplace and support their daily operations. I'm also accompanied by my partner, Joe Lipchitz, who is a partner in the firm's Boston office and also a member of the firm's force majeure litigation team. Joe represents businesses, officers, directors, and high-level executives in the technology, healthcare, financial services, and media industries in civil litigation nationwide. Now, before we begin, there are a couple of housekeeping matters I'd like to get in order. The first is you'll notice at the bottom of your screen, there is a section for Q&A. You can submit questions that way. We will see them as they come up. We will try to address them as we can. We may have to wait until the end, depending on time constraints. If we are not able to answer your question by the end of the webinar, we will follow up individually. Today's program has been approved for continuing legal education credit in Pennsylvania, Minnesota, New Jersey, and Delaware. We also have an application pending in Florida. Now, we hope to be able to obtain accreditation within other states in our footprint for the remainder of our webinar series. Now, in order to verify your participation at two separate points during this webinar, we will display and verbally announce CLE codes that you must record and report back to us within a survey that you'll receive via email following this program. And once we receive your survey response, we will email you a certificate of attendance. And then finally, no program conducted by lawyers would be the same without some sort of legal disclaimer. So here goes. The provision and receipt of the information in this presentation is not legal advice. It does not create a lawyer-client relationship, and it should not be acted on without seeking professional counsel who have been informed of the specific facts. So with those housekeeping matters out of the way, let's begin. Next slide, please. So I'd like to just go through the roadmap for the next hour that we're going to spend together. We've just done the introductions and housekeeping matters. What we'll go into next is an explanation of force majeure and why it's relevant today. We'll also talk about the applicability of force majeure and drafting considerations for the contracts that you either have that are existing or for prospective contracts that you're in the process of drafting. In addition to force majeure, we will discuss other UCC and common law doctrines that operate in many of the same ways as force majeure will as a contractual doctrine. We will try to provide litigation and practical considerations regarding force majeure and these other doctrines throughout the program. And finally, we will wrap up with some cases to watch that involve cases that have in the last month or two already been filed regarding force majeure issues in the COVID-19 space. So next slide, please. So before I begin into the substance of this, I want to make clear that our firm is prepared to assist clients with these issues. In addition to practitioners in our corporate practice like Sweta who deal with these issues on a daily basis, the firm has created two interdisciplinary teams that can assist with these issues. So the first team is what we call the state COVID response team. And that is a group of attorneys from all over our footprint that have been tasked with tracking the relevant orders from various governments regarding COVID-19. So these can be anything from orders of governors. These can be recent decisions that that are relevant. And why that is helpful is when you're considering whether invoking force majeure, these types of declarations or court orders or decisions could be helpful because they can have some language in there that may help you to show that force majeure should be invoked based on the language of your contract. So we're on a constant basis tracking that. That is what that team does. They meet on a weekly basis. They provide the lawyers in our firm in that jurisdiction with a daily update regarding these types of orders. So that is one team. The second team, and if we could advance to the next slide, this is our force majeure litigation team. And as you will see, it is comprised of approximately 25 litigators from our firm, from across our footprint. And our goal with this team is to become knowledgeable regarding the legal aspects of force majeure in each and every one of the jurisdictions in our footprint. So to do the background research to know what the principles are, and also to track and monitor recent cases involving force majeure so that we can be ready to assist clients with these issues. Next slide, please. So what exactly is force majeure? Well, it's a French term that means superior force. And essentially, it's a contractual provision that when certain events occur, they can excuse or suspend a party's performance obligations under the contract. Now, because it's a contractual doctrine, it has to be invoked contractually. And unfortunately, prior to the last several months that everybody's been dealing with, many people probably didn't think about a pandemic being something that would be a force majeure event. And although force majeure provisions are found in many, many contracts, they're often treated as a boilerplate. Not a lot of initial thought goes into them. And unfortunately, you find out after the fact that sometimes they're not going to be adequate for the purposes that you're going to use them for. So you have to be creative. And we're going to talk today about some drafting tips for prospective contracts going forward, but also, how best to deal with the contract that you have right now. The one point I would make that I think is really significant about force majeure issues is it's very dependent on three things. And it's going to be determined on a case-by-case basis based on these three things. The first is, not surprisingly, the language of the contract. Some contracts have very expansive force majeure provisions. Some might have a sentence or two. They usually have something in there. Sometimes it will be helpful, sometimes it won't be. But you're going to be bound by the language in the contract that you're dealing with. The next is the law of the jurisdiction that's going to govern the contract. And again, and we will talk about some of these today, there are significant variations between the jurisdictions in the United States on how they handle these issues, from issues of foreseeability, what these catch-all phrases will look like and how they are enforced. There are so many variations that it's not just the language of the contract, but also how the particular jurisdiction handles that. And finally, it's the specific facts of the case. There are a lot of issues that once you're in litigation dealing with this, you look first at the language of the contract and what does that jurisdiction do with it, but also you have to look at the facts of the case. Were there performance issues beforehand? Was the force majeure event really the cause of the inability to perform? So all three of these things make this an issue that you can only talk about so much generally. We're going to give you as much generally as we can today, but know that this is a very much a fact and case specific issue. So if we go to the next slide, please. So why is force majeure relevant today? I think everybody that's on this webinar right now has been impacted by COVID-19 one way or the other. Many of us are still working from home, and it has really wreaked havoc on contractual parties' ability to perform their contractual obligations. And we have a couple of examples here on the screen. First are supply chain issues. As everyone knows, this virus originated in China, and that means China was ahead of the curve on dealing with this. They had a couple month head start on us. But what that also means is if you have a Chinese supplier of, raw materials or component parts for a product that you make, you might not have been able to get that here in the United States. So right there, that could be a force majeure issue. Travel restrictions, stay-at-home orders. These are all things that nobody really anticipated until we were starting to see it. And these can obviously affect contractual performance. I mean, if you have a conference scheduled and attendees coming from all over the country and you have travel restrictions or stay-at-home orders, that conference isn't going to happen. So again, that is how this virus has affected contractual obligations. Shutdown of businesses. So, we're just starting to open things back up slowly, at least here in Pennsylvania. But for a couple of months, we've had the shutdown of non-essential businesses. And so if you're a manufacturing facility that is not deemed to be essential, you can't produce your product. And even for the businesses that have been deemed to be essential, sometimes those businesses have had to shut down because of potential outbreaks in their facilities of the virus. I mean, you've seen in the news in the last several weeks of several meat processing facilities in the United States that have had to shut down just because of exposure to the virus and workers becoming sick in those facilities. You also have prohibitions against gatherings of large groups of folks and social distancing requirements. I mean, these can wreak havoc on certain events and certain plans, depending on what they are. I mean, one of the things that we've seen a lot of are weddings. You have a lot of weddings that are having to be canceled. Large conferences or gatherings of folks like that, those have had to be canceled. So what this has done is it has caused parties to do two things. Number one, review existing contracts to say, I'm either going to have problems performing under this contract, or I anticipate that my opposing party to this contract is going to have problems performing. So I need to look to see, what does the contract say and what are the effects of either one of us not being able to perform contractual obligations. And it also should give any party pause who is in the process of negotiating an existing or a prospective contract, to think about, as I said before, a lot of the force majeure provisions were boilerplate and nobody really thought about pandemics as being an issue. They should be now. And so what can you do if you are in the process of negotiating a contract to make your force majeure provision better and to deal with the type of situation that we're in right now? So if we go to the next slide, please. So the force majeure analysis is, it's a multi-part process. The first step in that process, I believe, is to really narrow down and consider, what is the force majeure event? What is the reason why I'm concerned about performing my contractual obligations? And again, it can be a number of things given what we've seen here. Can it be the virus itself? Sure, in certain circumstances, I imagine you could make that argument. But it's the residual effects of the virus is what we're seeing more. Sweda will talk about, is this considered to be an act of God? That's remains to be seen, and we have some case law that can kind of give us an understanding as to how a court may respond to that. But really, it's more than anything, we're seeing these governmental orders. People saying, well, I can't get in my facility to do this, or to make this product, or to fulfill this supply requirement. I just can't do it because I have a government order telling me to stay home or shutting down my business. So there are a number of things, and the really important first step in this analysis is to say, what is it that is causing these contractual performance problems? And you also have to ask yourself, are there other things that could confound that? Are there other events that maybe are tangentially in the background that could affect contractual performance? What you have to also look at is, look at the history. Were you at risk of not being able to perform under that contract prior to any of these events happening in the first place? And additionally, look at what performance really means. Does it mean that performance is completely impossible based on that event? Or is it simply more difficult or going to be more expensive? And you need to ask yourself these questions at the outset, because to the extent this goes to litigation, you better believe your opponent is going to be asking these questions and seeking this type of information in discovery. So once you've somewhat narrowed down what the particular force majeure event is, obviously you've got to go to the contract and you've got to look at what that language is in the contract. So with that, I'll turn it over to Sweta Gandhi, who is going to handle contractual interpretation.
Thanks so much, Jared. Could we go to the next slide, please? So as Jared mentioned, this is a contractual requirement. If the force majeure clause is not in the contract itself, you cannot avail yourself of it under statute or common law. And in addition to that, they come in all types and sizes, excuse me. But for the most part, the common elements that are generally or usually included in force majeure clause are a list of specific events which the parties have agreed would excuse performance. Many times you see what we call a catch-all phrase, which is a phrase that says, and any other event that is outside the reasonable control of the parties. We are often asked to look at whether or not the events were foreseeable or not. Sometimes, but not always, they will include notice requirements so that the party who would otherwise be in default is required to notify the non-defaulting party of the force majeure event within a certain amount of time. They may have obligations to mitigate. Now, those may be specifically in the provision, but they may also be a requirement under state law. And then you have to look at whether the force majeure event just postpones performance or if it requires a termination of the contract. Now, it could be that the postponement may not work for you because you need a supply tomorrow. So sometimes, you rely on the mitigation obligations in that point where contractually they're required to supply if using best efforts. Now, as Jared mentioned, these differ widely state by state. Some states have a lot of case law on force majeure. Some states have very little. And we don't know if a party will be limited to just the events listed in the catch-all phrase because that is also very state dependent. So for anyone drafting force majeure clauses at this point, the best practice is to look at these sort of elements, make sure that you are understanding what's required in your particular jurisdiction. And if your jurisdiction does not address the issue, then perhaps looking to other jurisdictions who have much more case law on the subject to determine if its case law may apply in your state or could be applied in your state. Next slide. So I want to go through a couple of sample force majeure clauses. I've highlighted a couple lines in each of them to talk about how some of them, how they're tied to the elements that we just talked about. So in the first force majeure clause, you see that this one is quite short. And while it lists the elements of having certain events identified and does talk about causes beyond a party's control, it does not include other provisions such as notice requirements or mitigation, or really what's going to happen as a result of the force majeure, whether there would be a termination event. In the next clause, you see that there are many events listed: acts of God, they have acts of terrorism, epidemics, but noticeably they don't have acts of government. So that may be a problem in the particular case of COVID-19. This clause does also include mitigation in terms of saying that a party is to use their best efforts to ameliorate the effects of any failure or delay. And it also, interestingly enough, in this case, talks about allocation when it talks about that a party cannot discriminate against the fund in favor of any other customer in making the services available. So you can see that the force majeure clauses on these pages address very different issues, and it's highly dependent on the facts of a case whether one is really better than the other. Next slide.
And Sweta, while you're transitioning to that, we did get a question I think is relevant to what you're talking about right now. The question is, many force majeure clauses don't mention virus, disease, pandemic, or epidemic. Are they part of force majeure without being expressly included?
So the typical lawyer answer for this one is it depends. As we're going to talk about in a couple of slides, if a clause does not mention sort of virus, disease, pandemic, or epidemic, then it's possible that it could be included if a court determines that by using the phrase and any other event that is beyond the reasonable control of the parties would include events that are not listed. It really depends on the state, because there are states where there is a strict compliance of the contract, meaning that the state court will only include those events that the parties have listed as excusing performance. Sometimes you can ameliorate that by using some, what I call magic language, which we will also talk about for the states in our footprint. So really the answer is it depends what state you're in and what state's law governs the contract. So going to the next force majeure clause, interestingly enough, in this force majeure clause, they don't list any events. They talk about events that may delay or prevent performance, but they don't really define what those events might be. It does here in this case talk about the fact that the period for performance will be extended, so it's not a termination provision. And it does require notice to be provided. So as you can see, we've looked at three very different force majeure clauses with different elements in each. And depending again on the facts and circumstances of a situation, these may completely cover you or they may not. And we'll get to that in the next couple of slides. So I just want to point out here the first CLE code. It's 512370. Next slide. So what's included in the next few slides are an analysis that we've completed of the elements in each of the states that where we are located. The reason I want to focus a little bit, and we won't spend a lot of time on this, is that different states, again, require magic language and other states do not. So if you take a look at Delaware, for example, and I will mention this at the outset, every state looks at force majeure clauses very narrowly. They won't expand upon what the party's intent was. They really look to the language of the contract. And so in Delaware, for example, if you want to extend the application of excuse from performance for events that are not included in the list of events, it's not enough to say that it is any event that's not in the reasonable control of the parties. It is required, however, that if you say include language that says any reason whatsoever, there is some case law that says that that would serve to extend the list of events to any reason whatsoever. So again, it's important to look at the language of the contract in comparison to the state that you are located in. If you could go to the next slide. I just want to point out, for example, there are, as I said, there are states that have a lot of case law on these particular elements, and there are states that have none. So Maryland, for example, while Maryland has case law on force majeure, there's no real discussion of these particular elements in any of those cases. Could we go to the next slide? And one more. Thank you. So I wanted to point out New York. New York, of all of the states in our footprint, probably has the most force majeure for cases where a court has actually analyzed these elements. As I mentioned, most courts do narrowly look at the force majeure clause. You can't have a general catch-all phrase in New York, but if you use phrases such as for any reason or other similar events, any cause, whether similar or dissimilar to the foregoing, there is case law that says that that will extend the list of events that you have included beyond just the specific events. In New York, for example, you have to demonstrate that the event was not foreseeable. And you must make an attempt to perform in order to invoke, so there is some mitigation requirement in New York as well. Courts have also gone to look at the industry practice of the events that might excuse performance. So these are all important factors to look at from a state-by-state analysis so that you can make sure that when you're drafting, the contract covers the relevant elements in the way that they're required to be covered in your particular state. Next slide. So I wanted to spend a little bit of time also talking about whether or not COVID-19 is an act of God. Now, most force majeure, not all, force majeure clauses include acts of God as an element that would prevent performance, or a list of the elements that would prevent performance. In order to qualify as an act of God, the excuse of performance has to be due to a natural event. It can't be a man-made event to be considered an act of God. So in this particular case with COVID-19, there is some discussion about whether or not COVID-19 was actually a natural event or if it was created in a lab, not in any way specifically to harm people, but just created in a lab, and it was somehow entered then into the general sphere. And now we know that, and everybody agrees that the COVID-19 virus did come from an animal source, but we don't really have any case law in the United States that talks about whether or not an animal source will be considered a natural event. So, most of the cases surrounding force majeure talk about natural events such as natural disasters like tornadoes and typhoons and hurricanes and floods. We don't really have a lot of case law that looks at whether or not a virus that may have come from an animal source would be considered an act of God. So assuming that COVID-19 is an act of God, and a court is able to, to figure out whether, we have some information finally that says that it was not created in a lab. Otherwise, whether or not the act is a natural event may be up to a jury to decide. But the second factor is it the sole event causing the breach? So could you go to the next slide, please? So we, again, have looked at the definition of act of God in the states in which we have offices, and looked at how the courts have applied the act of God as an excuse. So you'll see that in most cases, the act of God has to be the sole cause of the need to excuse performance. So if you, for example, if you have, for example, in the COVID-19 sphere, if COVID-19 itself is not the reason for your shutdown or your inability to perform, because what really shut you down is a government order, then there is an intervening act in there beyond the act of God, which in many cases, based on current case law, would prevent you from invoking act of God as an excuse from performance. I will point out that Maryland is sort of the outlier in this. They have said that it must be the immediate cause without which the loss would not have occurred. But they do allow apportionment between the loss and an act of God, and allow the parties to have to share the responsibility of, to share the responsibility between what is an act of God and what is the intervening event, in which case the breaching party would be responsible for the intervening event, but not for the act of God that the damages might have occurred from. Next slide. Next slide. So what about the defense of government orders? As we've talked about, the force majeure clauses are very narrowly interpreted. We've already talked about the fact that there are many states which require that you list very specifically the events that will excuse performance. So could you use the defense of government orders? The first question is it included in the list of events? I think it's very important, and I've seen contracts recently that did include government orders, or government regulations as an excuse from performance, and I've also seen contracts without it. It's really important now that we know about these issues and the effects of COVID-19 that we include government orders in our force majeure clauses. In some states, perhaps you can get it into the catch-all clause, but my recommendation is to include it as the list in the list of events to make sure that you don't lose that opportunity. And then it really has to be that the government order made it impossible to perform. So, you know, being in a law firm, we were all able to shift from working from home. So even though the government orders required stay at home for all of us, we are obviously still able to perform our jobs. And so that would not be an excuse for us in a contract necessarily, where we would not really be able to invoke force majeure. But there could be somebody who is mostly in the sales business. So let's consider a pharmaceutical company whose salespeople generally make sales by going, you know, to different doctors' offices and talking directly with staff and the doctors about the pharmaceuticals they have to offer. So is it fair to say that a government order which shuts down these doctors' offices and the inability now for the pharmaceutical reps to actually go visit and talk to doctors about their offering, is it made impossible? You know, I think it's going to depend on the certain facts of the case for sure, but it may be that a court finds that it's not impossible, that you could still meet with, you know, your doctor through a Zoom call. And so while that is now an economic hardship in order to try and make your sales, it may not win the day in terms of allowing you to excuse performance under a contract. Next slide. So there are some of the other remaining elements, which I'm going to spend just a little bit of time on. We talked a little bit about foreseeability. Was the event foreseeable? And so if the event was a government order, maybe not foreseeable because this has never happened in our country before. However, if you're in the medical field, it may be that a virus interrupting performance of an agreement is foreseeable. You know, maybe you were affected or your industry was affected by SARS. And so a court may find that in your industry, it is foreseeable that a virus could affect performance. We've touched a little bit on whether or not there's an obligation to mitigate it. The recommendation from us is that even though it may not be in the actual clause, you're always better off trying to mitigate any damages and any losses that you particularly can without, it's a much better way to be able to keep your relationship with the counterparty. And as we talked about before, some of the contracts that we look at have force majeure provisions which suspend performance, and some of them have termination. So it would be a good idea when looking at suspension of performance or termination to consider whether or not you want there to be some best efforts made to mitigate in an event where you need a product, say, right away and your supplier can't deliver. And then finally, is performance impracticable, impossible, or not profitable? And in terms of a force majeure clause, if performance is impracticable and impossible, that may excuse your performance. But if performance is not profitable, that is not going to excuse your performance. And I think Joe will be talking a little bit about, or a lot about impracticability and possibility in terms of how they may be used under the common law doctrines that are available. Next slide. So I just want to end with a few drafting tips. As Jared mentioned before, don't treat your force majeure clause as boilerplate. I think there's obviously a heightened sense of looking at these clauses to figure out whether or not they're going to assist in excusing performance. Review the list of events very carefully. Do they represent the types of activities that are commonly included in force majeure events in your industry? And it's very important to look at whether or not, have you done your due diligence to look at what other contracts in your industry might include as force majeure events? Obviously for COVID-19, you want to make sure you include government orders, epidemics, pandemics, but consider carefully the other events. How applicable are they to your industry? And have you really included everything that could affect you? And then you may want to broaden some events. So for example, in a contract for a venue rental, you may want to include threats of terrorism in addition to terrorist acts. So for example, you may have a convention happening at a hotel and someone calls in a bomb threat. Well, not necessarily a terrorist act, but it is a threat of terrorism. And if a court looks at these acts as narrowly as they do, then it's possible that you may not be able to excuse your performance as a result of threats versus actual terrorist acts. And then look at whether the event would be foreseeable. As we talked about, in the medical industry, it's possible there might be an event that was foreseeable, like COVID-19, because they've been affected by other viruses in the past. So court may not excuse performance if it's something you should have been able to foresee. Next slide. Improve your catch-all language. I think this is extremely important. In addition to the list of events, look at the governing law of your contract and determine whether any magical language needs to be included. Should you include any event similar or dissimilar to the foregoing, or any reason whatsoever beyond the control of the parties? Those may be more effective in many states in terms of broadening the list of events that would allow you to excuse your performance. Check the law in the governing jurisdiction to see if there's anything case law that gives you an idea of how courts have previously ruled. And consider including specifics about types of mitigation efforts that are expected. We recommend that you do not try and list every possible event. If you miss something, courts are going to be more likely to limit you to the listed events instead of allowing a broadening of the provision. And with that, next slide, I think I'm turning it over to Joe. Oh no, to Jared, sorry.
No problem. Thanks, Sweta. So Sweta talked a lot about the force majeure provision, which arguably is the most important contractual provision for you to look at when doing this analysis. But that doesn't mean there are other provisions in the contract that aren't going to be relevant. And this is a list of just a few. So obviously the dispute resolution procedure. This type of provision in a contract will specify both the timing and the steps that will need to be taken to resolve disputes. So this could be anything from the notice of the force majeure event to steps that you have to take before you can bring litigation. So you might have to provide notice of a default. You might have to give the other side an opportunity to cure that for a certain amount of time. You might be required to endeavor in negotiations between high-level executives for a certain amount of time, and then go to mediation, and then go to litigation. So just keep those in mind as you're reviewing your contract for these types of issues. Another provision that you want to look at is your choice of law or your choice of jurisdiction or venue for disputes. So this will tell you, as we've said before, there are a lot of discrepancies between the various jurisdictions and how they handle these issues. Your contract might tell you right off the bat which jurisdiction is going to govern. So that obviously is important. It may also tell you where you need to file suit if you get to that point. So you're going to want to check for those types of provisions in the contracts. Another one that is relevant is time is of the essence provisions. When you see something like that in a contract, that usually requires the contractual obligation to be performed very strictly in accordance with the time periods set forth in the agreement. And force majeure may give you an opportunity to avoid breach if you can't hit those time periods because of a force majeure event. But obviously, one of the things you want to look for is to see if there is a time of the essence provision in the contract. Termination, as Sweta mentioned before, force majeure, depending on the contract, depending on the jurisdiction, it is going to depend. Number one, is it just a temporary cessation of your obligation under the contract, and then once the force majeure event passes, everything goes back to normal? Or does the force majeure event give you the opportunity to actually terminate the contract? So you will find sometimes language in the force majeure event, the force majeure provision that talks about that, but a lot of times there is going to be a separate termination provision that will deal with that as well. Material adverse change. this type of provision permits cancellation of a contract if an adverse change significantly threatens the fundamental agreement in some sort of material way. It's somewhat akin to the common law frustration of purpose doctrine. You see it in a lot of merger and acquisition agreements. So it's similar to force majeure, but yet it's another provision that you should look at and look for in your contract. And then finally, liquidated damages or limitation of damages provision. These types of provisions will limit the types of damages that can be recovered in a breach of contract action. And a liquidated damages provision is going to say, well, your damages are set at X. So keep that in mind and see if there is any interplay between the force majeure provision and those types of damages provisions in your contract. Now, one of the questions that we have gotten so far is, what happens when you don't have a force majeure provision in the contract, or it's not helpful? Are there other areas of the law, such as the UCC, that could be helpful? And so that's a great segue to my partner, Joe, who is going to present on those issues. So Joe, take it away.
Thanks, Jared. So as Jared and Sweta have discussed already, reliance on the contractual force majeure provisions in light of COVID may not be helpful under the circumstances, either because it was boilerplate or it doesn't include the specific event that's affecting non-performance, or because of the law of the jurisdiction. So parties will often have to invoke common law principles, and we'll be discussing the four most relevant ones in light of COVID, and that's the UCC provision, the doctrine of impossibility, frustration of purpose, and illegality. If we could go to the next slide, that'd be great. So the UCC obviously governs the commercial sale of goods. And what UCC section 2-615 provides is that a delay in delivery or the non-delivery is not going to be a breach if the performance is rendered impracticable by an occurrence of an event that was the basic assumption underlying the contract. So in that case, if a seller's capacity to perform is only partially affected, then the seller must allocate among the customers in a fair and reasonable way. So for example, Jared gave the example of importing from China. So if because of COVID or government orders or travel bans, that the amount of raw material or basic component goods that need to be imported to make your product has not been eliminated but greatly reduced, then there is an obligation under the UCC to fairly allocate among your customers in a fair and reasonable way your product and performance under the contract. The UCC also requires that you must reasonably notify the buyer of any delay in performance or any allocation that you're going to make under the UCC. It's important to note that both under the UCC and these common law doctrines that we're going to be discussing, that impracticability does not mean economically difficult or less profitable. Think of it as more akin to impossibility. So if we could go to the next slide, please. So let's talk about two contrasting examples that sort of illustrate this basic principle. So in the Harriscom case, you had parties entering into a contract to sell goods that would be delivered to Iran. And subsequently to that time, the government issued orders classifying the goods to be delivered as, quote, military equipment, such that performance would not be allowed. And the court excused the party's performance and said there couldn't be a claim for damages or breach under the circumstances, because those government orders in how they classified what was previously as legal goods that could be delivered was unanticipated. So again, as we've talked about, sort of the analysis of foreseeability becomes very critical in undertaking the analysis under these common law and UCC provisions. Contrast that with the next case that's at the bottom, which is the unique eatery case. There, the buyer was going to buy the debtor's liquor license, but in order to monetize that liquor license, he also needed to get the lease to be able to take over the debtor's lease. There, the landlord refused to allow the assignment of the lease, and the court there did not allow performance to be excused, reasoning that the landlord's refusal to cooperate was not an unforeseeable event. So again, as we've talked about in this sort of recurring theme here, is that whether you're under the UCC or under the common law doctrines, the holding is going to be very case specific on the facts of your specific case and the parties' interaction in entering into the contracted issue. If we could have the next slide. The next common law doctrine that is going to be fairly typical in dealing with COVID-19 performance issues is impossibility. Now, impossibility will excuse performance when there's one, an unexpected intervening event, two, the parties assume the event would not occur. So the basic assumption of the contract didn't envision this. And the event makes performance impossible. So as we've said before, impossibility is not financial inability or hardship. It's not a lessening of margins or profitability. It's impossibility. And its impossibility is analyzed from an objective, not a party subjective, but an objective standard on what is indeed impossible. So let's illustrate this point. If you look at the case cited at the bottom, the Gavigan case, that was a case where parties entered into a contract where one party would go on to a non-contracting party's land to obtain topsoil and deliver it to the golf course to spread it out. The parties to that contract had coordinated with that non-party to the contract in entering into that primary contract. And yet when it came time for performance, that third party unanticipatedly changed their mind and denied access to his land to grab the topsoil. And there the court released both parties from performance and said there could be no claim for breach because that unanticipated event had made performance of the contract, the delivery of the dirt from the third party's land, impossible. If we could go to the next slide, please. So the next common law doctrine is a cousin to impossibility. So you want to think of impossibility and frustration of purpose as very similar concepts along the spectrum of excusing performance. So the Mass SJC has a really good way of looking at this from my perspective. Performance still remains possible under a frustration of purpose doctrine, but the value of the contract, the essence of the contract, why you were entering into the contract in the first place has essentially been gutted by that unanticipated event. If you could go to the next slide, please. And again, under frustration of purpose, you'll see that the elements are largely similar, if not identical, to impossibility. So that is being the event substantially frustrates the party's principal purpose for entering into the contract, the non-occurrence of which is a basic assumption of the contract, and the event is not the fault of the party trying to invoke the defense. So let me touch on 3 examples that sort of illustrate this basic principle. So in the Chase case, you had 2 parties entering into a contract for the purchase and delivery of concrete barriers for the express purpose of one party supplying them to the Mass Highway Department for their highway betterment project. But then after entering into the contract, the Mass Highway Department decided it wasn't going to use concrete medians anymore. There, the court excused performance. Now, obviously, one party could still physically and logistically deliver concrete medians. There was nothing prevented that from happening. But the entire essence, the thrust, the purpose, as agreed to by the parties in entering into this contract, was that these concrete medians were going to be used for the mass highway projects. And there, because of that, the contract, the court said the contract performance would be excused under a frustration of purpose analysis. You have a similar analysis in the rental context in the Saab case. There, a commercial tenant was excused from further payment of rent because the building commissioner decided the premises could no longer be used to operate as a restaurant, and the lease provided that you couldn't be used for any other purpose. So again, there the parties had agreed that the entire thrust, the entire purpose of that contract was for the purpose of allowing it to be used as a restaurant. Contrast that with the last case, which also touches on this concept of foreseeability and the essential nature of the contract. In CARA, a parent has done what so many of us have done these days in trying to get our kids ready for colleges. She arranged for a lease arrangement so her daughter could go to school locally. But as part of the application process, she still needed to get her daughter's visa application approved that would allow her to re-enter the United States and start her college career. The visa application was denied, and then she tried to back out of the lease. And there the court said, well, wait a minute, the tenant, you knew, or you should have known, that the government's denial of your visa was a distinct possibility, and therefore you assumed that risk. It's not an unanticipated event. Also, under that case, the parties entering into the lease, the landlord was just entering into a lease just like any other lease. The landlord, unlike in the other cases, was not entering into this lease with the express understanding and purpose that the lease would only take effect or was contingent somehow or being effectuated. The benefit was going to be derived from the grant of the visa application. If we could go to the next slide, please. The next common law doctrine is illegality. Now here, what we're talking about is when parties enter into a contract that's perfectly legal at the time of contracting, but then subsequently becomes illegal because of some government action. And there, the courts have typically held the parties to the same position that they found them in, and therefore excuse and reject claims for breaches and damages. This one is a particularly viable theory in light of the various COVID orders, shutdowns, stay-at-home orders that have been entered in various states in our footprint. If we could go to the next slide, please. So, stepping away from the cases now, I want to give you some litigation and practical considerations as you're dealing and wrestling with these force majeure and business interruption issues. First is consider non-contractual commercial solutions. What does that mean? It means try to work it out. And the reason for that is there is a lot of risk right now. There's the analysis for force majeure issues is very case specific. It's also dependent on the case law. And a lot of this case law is old case law or emerging case law because, quite frankly, force majeure events don't happen with all that frequency. We've also seen, as a result of COVID, courts being shut down and their operations being impeded, and therefore getting prompt judicial declarations is going to be very, very difficult. So there's risk for all contracting parties, and if there's a way to work it out and negotiate something, that should be your first thought in approaching these problems. The second consideration that you should have is a tactical one. Consider the effects of invoking the force majeure clause doctrines on obligations under other contracts. What do I mean by that? You want to be very thoughtful about when and where you're going to invoke force majeure contract or common law principles. Because once you do so, you may have other contracts, more significant contracts, that you don't want force majeure declared on you. And your adversaries, if you take a position in one case where you're invoking force majeure to excuse performance, but then subsequently are going to be trying to prevent force majeure from being used against you, that inconsistency will likely be brought out in court, and you don't want to be in that position. So you want to take a very thoughtful approach about when and where you're invoking force majeure. Also, in invoking force majeure in a contract, that may trigger disclosures and changes in reps and warranties in other contracts, such as lending contracts, mortgage contracts, and the like. So you want to be thoughtful about the collateral consequences of when and where you invoke force majeure on your business and other aspects of your business. Next, you want to remain cognizant of your post-invocation obligations. So by that I mean, once you invoke, do you have obligations under the contract or various common law doctrines to give notice, to make reasonable allocations, to mitigate damages? Those are the things that you should be very attentive to prevent claims coming back against you for breach of contract. You also want to preserve relevant evidence. If you're in a position of thinking about invoking force majeure to excuse performance, you are likely heading into an adversarial situation, and you're going to probably be obligated to preserve relevant information, emails, text messages, and the like from the relevant decision makers and employees and vendors involved in that contract. And lastly, avoid creating harmful evidence. And what I mean by that is that in all businesses today, businesses are finding ways to try to keep the business going. And very often you will have sales or marketing or customer service employees suggesting in emails and text messages ways that maybe the contract can't be performed, because of course that is their job. They want to keep the relationship going. But in the context of litigation, those emails can be, text messages can be particularly harmful because it shows you that indeed the contract can be performed and force majeure or common law doctrines are not applicable. So the best advice there is to get on a phone call with the relevant people within your business to talk through these issues rather than creating a wellspring of emails and texts with people offering their views, thoughts, and opinions on how the contract can be performed. If we could go to the next slide. Now, force majeure litigation has already started. So notwithstanding the limitations on courts, several notable force majeure cases have already been filed around the country. In California, Florida, Massachusetts, New York, Virginia. There are many more likely coming, and we can take away some valuable lessons from what's already been filed. Next slide. So the first major category of cases that have been filed are your commercial rent non-payment or rent abatement cases. For example, in the Palm Spring case, which is actually consists of 6 cases filed down in Florida, the landlord has proactively brought suit suing various commercial tenants, challenging the non-payment of rent and arguing that the force majeure provisions in the lease don't apply to the circumstances arising from the pandemic, and seeking a declaratory judgment that rent is still owed. Can we go to the next slide, please? And here, as Jared and Sweta talked about, you want to look at every provision in your contract to see the interplay between the two. And this case illustrates it. So for here, the landlord is invoking another provision in the contract that expressly excludes financial inability as the basis for non-performance under the lease. Now here you're likely to see the tenant say, it's not financial inability that we're not paying you rent, it's probably the government orders that have shut down the businesses. So this underscores another point that we've said throughout this seminar, that you want to focus on what the specific force majeure event is that's causing the non-performance issue. If we could go to the next slide. The next rent case is important because it illustrates another important principle that we've talked about today, which is focusing on the language of executive orders, government orders, and decisions, because those decisions may help you in your force majeure analysis. So for example, this was a case where the debtor filed a motion seeking the suspension of its rental obligations and invoking the common law doctrines of impossibility, impracticability, and frustration of purpose. Here, there was no force majeure provision that could be invoked. If we could go to the next slide. Now, while the court made no determination whether the government mandated closures would constitute an excuse of performance, the court on its own said, COVID-19 presents a temporary, unforeseen, and unforeseeable glitch in the administration of the debtor's bankruptcy cases. So here you have the court itself saying that COVID-19 presents an unforeseen and unforeseeable glitch. That may be particularly useful for those in Virginia, depending on the language of your specific force majeure contract and your contract in general. If we could go to the next slide. The last case really illustrates a lot of what we've talked about today and the need to identify, again, the specific force majeure event going into litigation. So this was a case where a parent had booked a foreign EF educational trip to Spain for her daughter to take place in April. And the EF affiliated companies then solicited her to purchase travel protection coverage, which specifically mentioned that it covered cancellation due to, quote, quarantines. Now, the complaint then alleged that the educational travel company and the insurance provider of the travel company failed to offer a refund. And the plaintiff argues that the Governor Baker's stay-at-home orders and the federal government's no foreign travel orders constitute a, quote, quarantine. Interestingly, in this case, the booking company of EF Education had a force majeure provision that excused performance resulting from a force majeure event, an act of government, or an epidemic. So you have this tension between two clauses, between two separate contracts, although they're related entities. So if we could go to the next slide. And there's many other cases that have been filed that we have been tracking, but the court's analysis in these cases are often going to reveal language, interpretation of language in contract, and interpretation of common law doctrines that may be very helpful to you and your businesses. I also note that the last CLE code is here. It is 72190.
Thanks, Joe. So that will conclude our webinar for today. I apologize if we did not get to your question. If it was submitted, not submitted anonymously, we will send you a response by email. Remember to keep an eye out for the thank you email with the CLE survey, that you can note the 2 CLE reporting codes that were provided during the webinar, and a link to the webinar recording and presentation materials will also be included in the thank you email. Finally, if you have not done so yet, please be sure to register for the next webinar in our weekly series titled Business Continuity Steps for Rebounding from the COVID-19 Pandemic, which is scheduled for next Wednesday, June 10th at 1 p.m. So thanks everyone for your attention. It's been a pleasure presenting to you. Thank you.